Hi everyone. I just wanted to do a quick video about sentencing under the the Youth Justice Act. The Youth Justice Act in Queensland is governed by a whole bunch of different sentencing principles, particularly in Section 150 of the Youth Justice Act. So, for instance, they have to take into consideration things like the court has to take into consideration the general principles that apply to sentencing of all people, the juvenile justice principles, the special considerations in subsection 2, which I think I've got on the next slide, the nature and seriousness of the offence, most importantly, the child's previous offending history, and any information about the child, including a pre-sentence report provided to the court to assist them in making a decision. So all of these things have to be considered when we're thinking about sentencing young people. In particular, we need to look at things also like whether or not they're Aboriginal and Torres Strait Islander, their child's relationship to the community, cultural considerations, and any considerations around programs and services for that young person in their community. The impact of the offence on the victim also needs to be taken into consideration, particularly thinking around the harm that that particular crime has inflicted on the victim involved. A sentence imposed on the child that has not been completed in the past, if that's an issue that needs to be considered. A sentence that the child is liable to have imposed because of the revocation of any order under the Act for breach of conditions, so breach of bail and so forth. And of course, the fitting proportion between the sentence and the offence in terms of its severity and so forth. So all of these things need to be taken into consideration. Important issues to consider are things like age of criminal responsibility, bail, which I talked about a little bit before, police interviews, whether or not parents have a right to be at the court, publication of a child's particulars, although this is no longer prohibited. As I noted before, courts are open now and young persons' particulars are a matter of public record unless somebody puts in a form to say that they don't want that to happen. Recording of convictions is important to consider, and of course the role of DJAG, the Department of Justice and Attorney General. The age of criminal responsibility and DOLI incapax, which is not having the capacity to make rational decisions or understand the consequences of their crime, or to be incapable of crime, basically. Now, I wanted to talk a little bit about age of criminal responsibility because it is actually quite young. If we have a look at the different ages of criminal responsibility across the world, Australia has one of the youngest, other than Cayman Islands, Cyprus, and a few others that are at 7 and 9. The typically 14 and up is more common across the world, as you can see in that graph there. Sentencing options for non-serious offences is what I'm going to be talking about mostly, although I'll talk about these ones very briefly. I won't go into a lot of detail. For serious offences, obviously there's a sentence of detention and that sort of stuff, depending on what the circumstances are. They might have a suspended sentence, or they might get released on probation, or whatever it might be. So there's cautions, there's reprimands, there's good behaviour bonds, drug diversion assessment programs, there's fines, youth justice conferences, which I've talked about before, probation, of course, also intensive supervision orders, which is where they have, well, it's exactly what that implies. It's intensive supervision in community. There's community service. There's conditional release orders, which is where they're partly in detention and partly not in detention. And of course, there is a detention order. When we're talking about unsupervised orders, because there are unsupervised and supervised orders in the community, depending on what the court decides. Unsupervised orders can be things like, obviously, dismissal, which is where the charges are dropped without conviction or penalty. There's a reprimand, where the warning is given by a court to a young person, and hopefully that will have an impact on the young person not coming back. There's a good behaviour order, where the young person must be of good behaviour for up to 1 year. And what it means to have good behaviour is defined differently depending on what the circumstances are. There's fines also, but this is very common in adult court, not so much a children's court, because it's based on the means of the offender, and not a lot of children have the means to pay fines. In the case of young people and children, it also depends upon the means of the parents involved, particularly around fines. So there are unsupervised orders. There's a whole bunch of supervised orders as well. Probation is probably the most common one, where the young person is supervised by a Department of Communities officer, and the young person must be agreed to be supervised. There's community service orders, where they perform unpaid work for a specified amount of hours. Again, the young person must agree. There's intensive supervision orders, where they're a little bit different, where young persons aged between 10 and 12 years for up to 6 months can be subject to an intensive supervision order. There's an agreed program of activities such as mediation, supervision, other activities. It can also be schooling, participation in a drug rehabilitation program, or whatever, basically. There's conditional release orders as well, and this is where they can have suspended detention order for up to 3 months. A young person must agree to a program of activities, work, schooling, counselling, community work, all of that sort of stuff. And if they breach any of those, of course, they're immediately subject to detention, or their case goes back to court. There's, of course, detention orders. That's fairly straightforward. Detention for up to 1 year. Higher court has the power to detain for up to 5 years, and I think this actually might even be up to 7 years now. 70% of their time is spent in a detention centre during that period of the order. And then there's these things called combined orders, which is where they can be sentenced to probation, community service for the same offence, depending on what's going on. It can be a combination of other things. I just want to give you a couple of examples of problems that can come out of these types of orders. Probation is one that's talked about in the work of Mark Halsey. For example, this particular participant who was interviewed talks about their probation and the way that they experience it. So the person says they've got to report in once a week. This is a young person. They have to reside at this address. They're not to drive a motor vehicle and not to drink or use drugs. And they say, you know, when you say you're not to drink or use drugs, what does that mean? They expect you to have no alcohol at all, and the participant says nothing. So what do you think about these conditions? It's not reasonable. Like the driving one, like I've actually spoke to my parole officer, and they're going to write to the parole board and ask them if I could have 2 drinks a day. So my alcohol limit can be 0.05. If it's over 0.05, then I get breached. If I go to a restaurant and have a drink and get caught, I go back in just for going out for dinner. So there can be unreasonable requirements depending on what the situation is, which can often lead to people being set up to fail in terms of probation and parole. Another one, this person talks about how they don't want to go back and live with their mums. However, every time they go back and live with their mum at their mum's place, they end up back inside. I don't want to go back to my mum's. I've already told them that. I want to get a job and a flat and that. Like, even if I tell them that, well, the only way you're going to get out is you've got to go to your mum's. I won't do it because it's just setting me up to fail. So this person is actually reflecting on the fact that they're telling the people that they can't go back to their mum's because that's the place that always leads to offending, yet the court or whoever it is insisting that part of their release should be that they end up going back to their mums. It's really problematic, and it's a clear case that the system is not listening to that person. There's other orders, of course, restitution and compensation for property loss, injury suffered by the victim, all of that sort of stuff, and that your means are considered usually in terms of these. License disqualification is another one that's quite common. There's also things like this, prohibited behaviour orders. Now this is obviously a UK one, ASBOs in particular, but the prohibited behaviour orders in WA are very similar, where there's an order on the young person around where and when they cannot go somewhere, who they can, you know, socialise with, all of that sort of stuff. So that can be another outcome, but only specifically in WA. They've been found to be incredibly ineffective in the UK and were withdrawn, even though they've persisted with them in WA. There's a whole bunch of reports. The pre-sentence report is prepared by the Department of Communities for the Children's Court, and it's typically involves information and assessments relating to the young person, the offender's family, and other matters. And of course, that report is considered in the sentencing process. The question of whether or not the young person has any input around this sentencing report is a big one, because sometimes they don't have a lot of time to prepare those reports. Overall, when we think about whether or not we're problematising sentencing and so forth, there are some young people that are genuinely incapable of reform because they don't have the capacity to ameliorate their circumstances in the communities that they live in. There's also, though, there's supervision orders that are considered, you know, a different form of public imprisonment, in fact. So intensive supervision orders can sometimes be as intensive as I'm at home, I ring my caseworker, I tell them I've got to go to the shop to get milk. I go down to the shop to get milk. When I get home from the shop to get milk, I ring my caseworker again and let them know that I'm home. So these can actually be considered sometimes a public form of imprisonment. It's because the conditions on the people are extremely high level and very difficult to fulfill. And of course, certain groups of young people can be subject to harsher penalties. Indigenous, ethnic and female young people in particular have been found to be subject to harsher penalties. Of course, overall, when it comes to other forms of sentencing, particularly mandatory sentencing, there are significant implications for Indigenous young people in particular. They've found that mandatory sentencing particularly impacts on Indigenous young people in that they're more likely to be subject to mandatory sentencing. So they might get 3 strikes in terms of having 3 offences, and then they're subject to a period of detention. Even though those 3 strikes might be stealing pens and pencils for school, stealing glue so that they can sniff it, stealing a deodorant can because they want some other form of inhalant. That's their 3 strikes and they're in detention. And of course, we know that detention leads to more goes in court and more crime in future. And I'm going to talk about that in a minute. All right, that's it in terms of sentencing. I shall speak to you soon. Bye.